All right, the next case before us is Bressi versus Thompson. Each party will have 15 minutes to present their arguments. Appellant may receive up to 5 minutes for rebuttal. Do you know how long you'd like to reserve?
Yes, 5 minutes. You're on.
All right, very good. Hopefully that will continue to keep working, and you'll know when that gets on the top, gets down to 5, is when your time for rebuttal has started. So
Wonderful.
if you're looking up there, just looking for it to get to 5.
Perfect, thank you.
The arguments are being recorded, so when you come up, please, number one, make sure you introduce yourself. Make sure that you stay behind the podium and that you speak in a loud voice so the recording can pick you up. If in this case you have any minors or victims or anyone you wish to refer to them by initials rather than their names, we certainly appreciate that. Having said that, the court has read your arguments, ready for your briefs, ready to proceed whenever you are.
May it please the court, counsel, my name is Laura Mills and I'm here on behalf of Dr. Bressi. I would like to start with why we're here now and move backwards, meaning that I would start with the actual attorney fees that were awarded in this particular case, which were in excess of $125,000 for the sanctions that Judge Cosgrove found. My files indicate that the attorney fee statements are in large part larger than the file itself. And although we had a hearing relative to fees, which lasted over the course of 2 days in December of 2022, 7.5 months later, while I know that there were a certain remand allowed for the court, 7 months later, we received a blanket order. All 125,000 fees were granted, even though obviously there was no detail by the court in any way, shape, or form relative to calculating the number of hours that were reasonable, that were necessitated by what the court found as frivolous conduct. So when you take a look at, there were obviously 3 counsels that participated in that. When you take a look at the Coakley Law Firm and their fees, there were a number of conversations between counsel, we don't know what for. There were a number of entries to a criminal case review, and there was an associate billing over $25,000, $30,000, or $40,000 worth of the invoice that was not even admitted to practice law in the state of Ohio. One entry shows it took 1.2 to put a 2-sentence notice of appearance together. We questioned the fees. We had an expert that questioned the fees and said these associate hours, they're over the top. I think what will help this court is when you actually take a look at the case list and the case docket for this particular case. Lots of certificate of services obviously that went out, but if you take a look, there was very little motion practice. And why was that? In the beginning, in a lot of the details that are in these fee statements, and like I said, they're larger than the briefs that were actually filed. And in these fee statements, it's time and time again, motion to dismiss. There was testimony at the sanction hearing, even by one of the counsel. Yeah, there was a lot of entries to a motion to dismiss, and a motion to dismiss is not even appropriate relative to the receiver. So all of the entries relative to the motion to dismiss, all of the entries for attending or reviewing the criminal docket or talking to Dr. Bressi's criminal counsel, it had nothing to do with this case. And it's replete with entry after entry after entry of items that did not have anything to do with whether or not there could be leave to file the receiver and whether or not the court was going to grant a summary judgment in regards to that. So the case list itself, very few motions were filed in this particular case. It is also a fact that you have seen in some of these briefs that there was a delay. There was no delay. No case was stayed. Even though there was a mention and there was a request to stay cases, no cases were stayed whatsoever. as a result. That order was never signed. There was in the beginning a discussion that the whole basis for this particular lawsuit was because there was going to be a contempt proceeding. And that contempt proceeding was supposed to be relative to whether or not Dr. Bressi and his wife would sign authorizations for their entire file, mind you, not their entire file relative to their defense against the 46 women who had sued them. To date, you can check the docket, the attorneys for Dr. Bressi have not released their files because they don't know how to separate out what would be attorney-client privilege, what would be work product, what would not be relevant. To this date, that case is still active. Nothing has happened since March of 2021, and guess what? Those files haven't even been released. The court issued a prior order that it should be released, and the law firm themselves said no. They filed their own motion to quash. There was a response to the contempt by the Bressis. The same response now that that law firm is asserting. What about attorney-client privilege? What about work product? What about all that? So the sense that Dr. Bressi didn't want to show up at what likely would have been a 15-minute, 30-minute hearing, the attorneys that represented him would have to be part of that, and that he came up with this whole delay tactic to file a lawsuit, it's really illogical and does not make any sense. Before we move on to the case at hand, we did cite two relative to these fees. We cited to the trial court in Summit County, to which I know Judge Cosgrove has indicated that it was good bedtime reading, but that law is no different than Stryker. Stryker's over $3,000, not $125,000, and it was whether or not the insurance carrier could participate and recover fees. If the person was wrong, is it the insurance carrier and is it the person that paid out of pocket? And the Stryker case said yes. The trial court level case, which is Oliver versus Silver, that Judge Cosgrove obviously kind of disparaged, addresses the deductible issue. So if you take a look at the transcript, and certainly in our briefs, we made it very clear that none of the insurance company representatives came in, none of the insurance companies were trying to recover their fees. All of the counsel indicated that the claims had not been assigned. In fact, Counsel Perdue told me that really it was none of my business what he did with the money. It was a personal claim and it was all his. So for some reason, $45,000 should go on his pocket. He can do with whatever he likes, when his deductible was $25,000.
Counsel, if that stuff isn't in the record, then let's
It is
stop.
all in the record. Yeah, I'm sorry, Your Honor, it's all in the record. That is verbatim in the transcript of the proceedings, absolutely verbatim as to what he said to me, is that he could do whatever he likes with that particular money. So I just referenced that Stryker case does not change things. The insurance company was Masnick in that Stryker case, and they recited case law relative to the insurance carrier receiving funds as well. We don't have an insurance carrier making any claim in this particular case. We also do not have the 46 women making any claim for any fees or costs in this particular case. And what's interesting about that is Judge Cosgrove makes a point to say in her order, these women did not need to be re-victimized in her order. There was also testimony that Collins, the receiver, indicated that Judge Cosgrove never thought the settlement amount was enough for the women. So there was a preconception. And so going back to the case overall, there are some important things that were in the case. One, Dr. Bressi is not convicted of any sexual crimes. There were sexual crimes that were alleged against him, 27. He sits here today with 0 against him. And the reason he was given a new trial is Judge Oldfield found there was a conspiracy within Summit paying physicians, and that conspiracy led counsel as well as some of the victims to embellish and make up stories against Dr. Bressi. He got a brand new trial. What's interesting and how that plays into this is what starts the little battle in February of 2019. The receiver, Collins, decides, well, maybe we should sue these lawyers for this conspiracy. So he sues 2 lawyers in December of 2018, I believe, first part of 2019. And Dr. Bressi says, well, wait a minute, those might be personal claims. Let's take a look at that confidential settlement. What's going on with this particular? I know that I assigned Summit Pain Physicians, and I might have assigned this, but I think these are personal. And all he does
You're down a minute left in your initial time.
Thank you. And all he does is file to amend the complaint. What is extremely important, and we're going to get there, is that that entire transcript was under seal. The order that came out in March of 2019 that went before this court had no record of a motion to enforce settlement. In fact, the previous order on what are we going to do on February 13th, 2019, Judge Cosgrove listed motions, none of which was to enforce settlement. This court said in its Court of Appeals decision that that Dr. Bressi did not argue the prejudicial nature. There is no motion to enforce settlement whatsoever. The complaint in this particular case was a deck action, was civil conspiracy. It was a breach of contract relative to not releasing the prejudgment interest. And most importantly, it didn't even involve the same parties. And we can argue about that. We've requested a de novo review, of course, and plain error relative to the parties. But the same parties were not involved in that case. And I understand why.
You're now in your rebuttal time.
Okay, I'll save my rebuttal. Thank
Very
you
good.
so
Thank you.
much, Your Honor.
Attorney Reed, as you come up, I understand you're arguing for all of your colleagues.
That's correct, Your Honor.
Very good, thank you.
For the record, my name is Orville Reed. I am counsel for David Perdue, and today I'm representing all of the parties, I believe, for purposes of this argument. First of all, let me address the first assignment of error, and that is that the trial court erred in granting summary judgment. I think we're limited to one issue, and that basically is the fact that the release of the attachment order in one respect was not filed on time. I think that's the way the brief reads of the report. At any rate, it's fair to say that if this court determines that the plain error doctrine is not applicable, then that disposes of assignment of error number one totally. Because the issues that are raised in this appeal were never raised to the trial court. And that has to do with the issue of standing, which was not addressed earlier. But if this court decides, as it did recently in the Russo versus Brissinger case, it was decided by this court in January of 2023, that the admonitions of Goldfuss should in fact be considered by the court before the plain error doctrine is adopted. And that is, the court should look carefully at the case and determine whether or not the interests of justice and the integrity of the court are put in peril by the decision, unless the plain error rule is applied. And the Supreme Court in Goldfuss specifically said the court should be very wary of using this as a universal tool, especially a universal tool just to change a trial court result that is not acceptable to the trial court or to the parties. First of all, so if the plain error doctrine is not adopted, that's the end of assignment error number one. But even if it is allowed, in other words, you consider the arguments on the merits presented with respect to the issue of standing, it is clear that this court should still affirm the judgment of the lower court for the reasons I cited, we all cited in our briefs. And that is, first of all, the assignment that Mr. Bressi gave to the court was a limited assignment there, but limited assignment. He assigned his rights to go against third parties to recover monies for himself, so against his partnership and against his former partners. He did not, in fact, waive his right to attack the settlement agreement itself, nor did he assign his right to claim a breach of the agreement. So the fact of the matter is that in the underlying case, 2014-042198, that was before Judge Cosgrove, he did attack, through his counsel, he attacked the settlement agreement and claimed that the receiver, Mr. Collins, had in fact breached the terms of the settlement agreement by disclosing in argument certain confidential matters. The court found that it was not error, and in fact, during that time, upheld the agreement. The hearing that was conducted in February of 2019 was upon the motion made by the receiver to have the settlement agreement declared to be an enforceable contract. So in her ruling on March 19, 2019, the trial court declared that there was no breach of the settlement agreement by the receiver, and secondly, the settlement agreement made between the parties was valid and enforceable. It was a viable contract. An appeal was taken by Mr. Bressi to the 9th District Court of Appeals, and that was case number CA29361. At that time, I think he was represented by an attorney by the name of Wilson. He appealed, and this court upheld for reasons that are enunciated in the brief and aids. The briefs were not well written, and they didn't present any prejudice in terms of either the breach that was supposedly committed by the receiver, or in fact, no reason to upset the court's determination that in fact this was an enforceable contract. That's in place. Then we get to case number, months later, after the Court of Appeals makes its decision, and case number 2020-09-2467 is filed, in which once again that agreement is attacked, and it is asserted that it should be set aside for a number of reasons. In granting summary judgment, Judge Cosgrove determined that there was no basis in law or in fact for the assertions that were made in that case. They were governed by the rule of res judicata. Now, the assertion is made, again, if you decide to employ the plain error doctrine, but the court ruled that the court did not address the issue of standing in the case. But nevertheless, this is a valid judgment of a court of competent jurisdiction, and there is no allegation of fraud or collusion on the part of anyone. So that decision in 29361 certainly serves as a basis for res judicata. And the court correctly determined that no attacks could be made on the settlement agreement. They raised one issue in 29361, and that was the issue of the receiver having disclosed confidential information unnecessarily. In this, they raised other issues that should have been raised in the initial appeal in 29361 that were not, and they could have been raised at that time. So all of these issues that were raised in 2020-09-2467, all of those, practically all those issues were resolved by virtue of res judicata. And the court correctly determined that the decision in 29361 by this court served as a basis for res judicata. They had an opportunity to raise whatever issues they wanted to raise. They raised one issue, they waived the rest, and res judicata applies. I cited a number of other cases and other rationale for why that decision was correct, and I'm sure the court's heard this. Finally, with respect to the issue of the sanctions, the court had already ruled, in fact, that there was no basis in law or fact for the various claims that were being asserted in this case. Let's take a look, for example, at the very first claim that was asserted in case number 2020, and that was a claim that there was no confidentiality agreement in the collective bargain, in the confidential Bressi master settlement agreement. And that is true. There was nothing set forth in the in the agreement that specifically addressed confidentiality. However, in each of the 46 releases that were executed by the women victims of Dr. Bressi, in each one of those releases, there was a confidentiality provision which precluded those ladies from discussing anything about the case, anything about the amount of payment, or anything about the terms of that agreement. And they were bound by that. And to say, as a basis for setting aside the agreement, for setting aside this agreement, that there was no confidentiality provision in the master agreement, totally overlooked, fraudulently overlooked the fact that each of the ladies had signed an agreement that contained a confidentiality provision. It was an absurd claim, and on that basis, they wanted to set aside the agreement. I think the court has probably been through the docket, they've read everything, and they see in the affidavit of Larry Scanlon and David Perdue that on the morning which the parties came together on December 28, 2016, to finally resolve everything, to sign all the documents, there was an issue that came up. Not of Mr. Scanlon's doing, not of Mr. Perdue's doing, but two lawyers were present who had previously represented Dr. Bressi and who had not been paid. They objected to the execution of to the filing of a release of the third attachment because of the fact they had never been paid. Judge Cosgrove said, I'm not going to allow that release to be executed, to be filed, until such time that I'm satisfied that these other lawyers who appeared that day specifically to protect their own fees should be protected, should be paid. And in fact, it wasn't until May that Mr. Brad Longbrake, who was counsel for Mr. Bressi at that time, and who made no objection to anything that was said or done that day during the hearing, as the court will note from the transcript. Nothing was said or done that day by Mr. Longbrake, which indicated his non-agreement with what was suggested by the court. It was then in May when an entry was finally sent to the court to release the last attachment order, and that was then filed with the court in November. But all of that stuff, all those facts, all of that incident were well known to Mr. Bressi because of the fact he was aware that the third attachment order had not been released, and became aware of that as early as December 2017. And furthermore, if this lawsuit was just about trying to figure out why that attachment order hadn't been filed, all he had to do was pick up the telephone and call Mr. Longbrake. But no, we had to file this lawsuit against these ladies and against these lawyers in an effort to set aside this agreement and to allege fraud against these lawyers who had engaged in no misconduct whatsoever. I would ask the court to I know it's familiar with the other arguments that I made with respect to the fees. I will tell the court that the Supreme Court decision is dispositive of this issue. Contrary to what counsel argues, it is dispositive of this issue. And basically what it says is that a party should not get the benefit of the fact that these lawyers had the foresight to have liability insurance. They should receive reasonable attorney fees. And that's what the court did. And the court can see the various amounts that were charged depending upon the rates that were charged by the lawyers. But having said that, I would ask this court to affirm the judgment of the lower court. There is no question in this case that the plain error should not be applied. The fact of the matter is, Mr. Bressi has had his bite of the apple many times. He's had it many times. And his, the whole concept of due process has been adequately served by the way the courts have treated him. I would ask this court to affirm the judgment of the lower court. Thank you very much.
May it please the court and certainly counsel, just a few points relative to the case that was before this court determined that Bressis were not parties to the Collins action and lacked standing to bring any claims in the Collins action. And they also noted, as part of a footnote, Bressi has not pointed to any part of the record reflecting the motion to enforce that was filed by the receiver, and this court's own review of the record did not reveal any such motion. That is true of all orders of the court prior to that February 13th hearing, which, by the way, there has been, and part of the lawsuit that was filed by Dr. Bressi, a lack of transparency. He wasn't in these particular hearings. These were occurring. And so when we take a look at the actual transcript from 12/28/2016, which is part of this record, that counsel referred to, that Long Break was gonna change the judgment entry, and Judge Cosgrove refused to sign, that's not in the transcript from 12/28/2016. In fact, it is counsel for Dr. Bressi saying, my concern is that I'd like to be able to tell to my client, it's approved, it's ready, it's in the judge's hands, and as soon as it clears Larry's account, he's gonna call the judge and she's gonna release it. It wasn't 7 months, it wasn't 8 months, it was 11 months later. And so that's the transcript that Dr. Bressi was not a part of, that he later learns of. And just a few moments, obviously, on this prior court's order reflecting res judicata. There was not a motion to enforce settlement. Dr. Bressi asked to amend his complaint. The court said, no, you can't amend it. And the receiver's going to continue on, and that got taken up to the Court of Appeals. It wasn't to ask that the settlement agreement had been breached. It was to amend the complaint for additional claims, and that distinction is as clear as a bell. And that's why we have cited to plain error and obviously a de novo review relative to this issue. It is not the same parties. And these claims are important. Confidentiality is one that counsel referenced. There was also a breach of the settlement agreement. The breach of the settlement agreement is on 12/28/2016. You have the entire agreement, all of the judgment entries, except the one that affects Dr. Bressi, except the one that induced him to sign this, isn't signed on that day, and it sits out there for 11 months. The receiver, he has no idea what the receiver's doing. The transcript demonstrates the receiver only talked to him once. The receiver's entire fees are under seal. No idea what monies are being collected other than lawsuits that are being alleged. And imagine this for just a second. There wasn't, obviously, no criminal court adjudicated these sexual crimes, no civil court adjudicated the civil claims. It was a resolution, and yet Dr. Bressi from day one was treated as if the settlement isn't enough, Judge Cosgrove said. This isn't enough, you haven't paid enough. Through this process, when we take a look at these two complaints, they're very different. Collins' case against Geiger, other attorneys, Keating and Malone, which, by the way, he alleged a civil conspiracy. And then when Bressi tried to say these cases, I believe these claims to be personal, what happened? The receiver dismissed all claims against the attorneys. This went up on the Court of Appeal. We believe that from the beginning, there was a complete control by the same lawyers that represented the women. They chose the receiver before the settlement. The receiver is billing for time before he's appointed, even before the oath and all the other things we argue, he's billing. The attorneys that are representing Bressi's interests against Summit, Payne, and Geiger, they are kicked out 5 days after Collins gets in, and the women's attorneys are then put in place. We have alleged that in this case, there was a breach of that agreement. The parties were not the same, and under the plain error, Russo's not new. 40 years ago, the Ohio Supreme Court said plain error exists in civil cases. If it's a manifest justice that has been breached, then, as these cases say, the court can consider it. It is a deviation from a legal rule. We know what that legal rule is. We don't know if Judge Cosgrove found claim preclusion or issue preclusion. She cites both in one entry.
Your time is up if you agree, if you conclude.
Thank you. Both in one entry, only claim preclusion in the judgment entry that ultimately gets appealed, and then both again in the sanction. We would ask that this case be reversed, obviously, relative to the summary judgment ruling. We would ask that it be, if it's not reversed, that it would be remanded relative to the attorney fees with an instruction on how to review those and the applicable deductible that should only have been considered. Thank you for your time.
And thank you both for your presentation. And all the folks in attendance, thank you for your attendance today and your interest in the matter. The court will take the matter under advisement and will issue a decision in due course. When that decision is made, the clerk of court will mail a copy to counsel on this matter. And the decision also will be released in the High Supreme Court's website.
Thank you, Your Honor.
Thank you.